Come on, somebody must have been an AV person. Yes?
Got it. Says record.
What's that?
REC.
That'll do it. That'll do it. Hello, everybody. I know some of you are still recovering from. Is it okay? If I'm over here, is it okay?
You're perfect. Wherever you want.
Yeah, he is.
I want to be in frame.
And I was like, yeah, like for sure. You know what I mean?
All right, so the first thing, I have to share something which I was discussing very, very briefly before class started, but I thought it would be something amusing to those of you that are paying attention to the details of the story. Not to make it. No, that's optional. Otherwise, I'll throw things. No. This was a blurb. There's a publication, those of you who are in real estate already know about the Daily Business Review, which also affectionately some of us refer to as the fish wrapper, that has stories about the real estate industry and legal business that's published daily. That's why they call it the Daily Business Review. And they always have transactions every day with no particular reason for them, except on Friday they also have a commercial and a residential. The rest of the week it's just commercial. And for some reason I was amused by the reporting of the sale of a one-story industrial building in Dane County that was the corporate headquarters for the General Stair Corporation. Nobody?
No.
They make stairs in a one-story building.
Yeah.
Okay.
Stairs.
No, it's real. I thought maybe you know.
Yeah.
Okay, well, so I'm a little attached. It's fine.
We're still like.
Okay, all right.
Okay, so did you see the news about the Patriots guy?
Yes.
That's I just have to share it because it's my shopping.
No sympathy. Because with the reputation that the team has, it's got to go a long way to the top.
I told her it was free advertising.
You know what? I said, sadly, I said the same thing about Jesse Smollett. And I can't believe what he did. What's that? It's publicity. It's a plus in the career. And actually, my son worked with him, so he knows he's a really nice guy, and it was just really a surprise. It just, anyway.
Did you hear about Jordan Woods? They're talking about him.
No.
Out there. So Jordan Woods is Kylie Jenner's best friend.
Oh, yeah.
She cheated on. So she made out with Chloe, who is Kylie Jenner's husband.
Shopping center or something?
And by the way, we're talking about her. I thought you threw it in there. Yeah, that's becoming a pretty awkward spot.
About this thing with crap, and not to get off the subject. You know, according to those folks up there in Juniper, I guess that's what they call
Jupiter, like planet.
They call a lot of people, video a lot of people.
Right?
And they got him in the, you know. Now, that guy's rich, that guy has great lawyers.
Yeah.
Will all the other people's cases be tied to his result at all?
Not. No.
So he could get off, and the other guy can burn.
Every case, in a situation like that, you can all do bad things. Bunch of you. There is no such thing as a class action defense in that kind of situation. It's not. It's case by case. And yes, the only way I could see, and obviously this doesn't apply to, the only way I could ever see legally one person's defense affecting the other defendants would be if the law was thrown out. If somehow the defense invalidated the law and they held it unconstitutional to prohibit you from parking next to a purple parking meter, okay? And so everybody got arrested for parking next to a purple parking meter, and it was held to be unconstitutional, and it invalidated the law, then everybody would get off. Otherwise, no. In the circumstance of this guy, and of course, because of who he is, and he's a high profile, he becomes more or less a public figure, and real estate doesn't include things like slander and libel, but there are different rules for public figures. When someone is held out to be a public figure, you can make comments about them, and you can't be held responsible for it. although there's politicians that would try and change that.
That's right, I heard that.
At least as of now,
What is-
that's the law.
So what is like the determination of a public figure? Because like now, at least in like the millennial age, I feel like everybody on Instagram ever calls himself a public figure.
Very
You
nice.
know what I mean? And so like, at what
that.
point could they be like, well, I'm a public figure? Like, no, you're a girl who just has like some Instagram following and like just did some terrible things.
Okay?
Like, you know what I mean? Like, what is
So-
like a
so
threshold?
Over 100,000.
So let me ask you a
Oh,
question.
like real followers? Like,
No,
who
that's
knows?
actually big account.
So it's basically a reasonableness standard, like say, how many people in this room would raise their hand and say they know who this Mr. Kraft is? Okay? And you probably have a lot of people. How many people would know who the Kardashians are?
Unfortunately.
Okay, but you know the names, right? Because they're out there. How many people would know the girl with the Instagram? Probably not very many. So it's kind of like that kind of standard.
Yeah, gotcha.
Again, off topic. But this is how I ask about anything.
That's okay.
Nothing about roasting. On a retrial. What? They said something wrong with one of the jurors. They said something wrong with one of the jurors. Have you heard the story? How he-
No, but go ahead, I'll try.
Oh, no, I hope you heard the story because I was confused about it.
Well, okay, so,
El Chapo's going on retrial. They're going on the case.
so,
They're like throwing away to put him
so
on
you're,
trial.
okay, so you're, especially, so remember, when you're dealing especially with criminal law, they're very careful to make sure things are fair. That's important. And fair is defined by, you know, you have the old jury of your peers thing. Okay, it's part of the Constitution, you're entitled to a jury, to trial a jury of your peers. So, it's supposed to be an impartial jury of your peers, unbiased. That is why, anybody here ever been called for jury duty?
I had it the other day, and it was.
Okay, so here's what happens. First thing that happens is you get put into, once you're brought into like the trial, where the lawyers from both sides are starting to talk with you, it's, I gotta try to say this the correct way and not by my cousin Vinny.
Oh my God.
It's, I'm inclined to
Say
say,
it like your cousin.
I'm inclined to say more dire, which is the southern way of saying it. It's voir dire is the correct way to say it. It is before a jury is impaneled, the lawyers have the right to question the jury, the potential jurors, to determine if they have any bias given to the case.
So is this the way to get out of it? Yes.
Yes, that's what I'm gonna say. A lot of people.
Yeah, but they know better than you do, okay? But for example, if the question were, do you ever ride the city bus? Okay? Typical answer would be, no, I have a car. Yes, I ride the bus. The answer they're going to have a problem with is, oh my God, those bus drivers drive like idiots, I would never do that.
Perfect.
Okay? So that's an example. So they examine the jurors and they look for those kinds of biases. Now that's a little bit of an easy, obvious one. So what happens is, if you have a trial of like an El Chapo, but I'll just give you an example, a criminal case, and you find out 3/4 into the case that somebody was related to one of the lawyers, something like that, that would make the juror not unbiased, not impartial. There are usually alternate jurors, so there'll be 7 if it's a 6-person panel, in case somebody gets sick. But if somebody is poisoning the panel because they have a prejudice, an approvable prejudice, that could be grounds for a mistrial. That would cause such unfairness that the defendant wouldn't get a fair trial.
Yeah, they said that El Chapo's lawyers fight for retrial after claiming jury was tainted.
Tainted.
This is true. But yeah, tainted.
Tainted. It's tainted. That's what happens. So you have the one guy. You have the one juror. Well, it happens. I mean, you never know what somebody's going to say in a jury room. But if they have a reason to say something that's going to convince the other jurors, that's a wrong reason, and like I said, they're related to somebody, or it's El Chapo's brother-in-law, or something like that. Okay? That's all right.
There was one girl that she was immediately dismissed because she said that she believed that everything was an act of God and they're
So yes, you.
I also
Yeah,
heard
right?
someone say
God is not a
one of
default
my
in this
classmates
court.
in my undergrad, she got out of jury duty by saying she finds all criminals attractive.
Whatever works.
Wow.
What she said it with a straight face. She's like, I know criminals very
See what I am.
Fine, you can get out.
Well, 'cause honestly, I mean, it's hard enough to find intelligent people to pay attention. You don't want any nut jobs. We didn't find Marilyn, did we? No? Oh, she's one of our...
She sits right here.
No, she's... Her lunch is here.
Oh, you have a Maryland over there?
Huh?
You have a Maryland over there?
There's a lunchbox, was delivered to her.
Maybe it's from
Oh,
there.
she sits right here.
Oh, that's the lunchbox with the Chick-fil-A.
Okay, otherwise, you know, when we go to break, we're all having chicken. Anyway. Okay, so
Thank you, Chick-fil-A.
I've been talking a lot about transfers of property and deeds and stamps and things. How many of you would like to have free property?
I would love it.
Okay,
Like you're giving it away, or like?
we're talking about gifts.
Oh, okay.
I don't have anything to give. You don't want the condo. Trust me, you don't want my condo.
You sure?
Huh?
I'll take it after the phase one.
Yeah, we'll pass. Okay, so, sounds like an odd topic, but people do gift property. Obviously, it happens in various situations, usually it will be a family situation. So, there's different kinds of gifts. We talked a little bit about things like life estates and remainders, and conditional things, but typical gift of real property would be a total gift, a complete gift, bless you, a gift by a deed, where somebody deeds the property to, I'm gonna, for purposes of, bless you, that's all you get. So, it would typically be like grandparent to grandchild, grandparent to parent, parent to child, something like that. That's the typical type of a gift, but it could be anything. Could be to a family member, it could be to a friend. But a total gift is just a deed, I'm deeding it to you. There could be a postponed gift. A postponed gift would be the situation that we talked about, the life estate. And this is very common with estate planning with older people, where grandma will convey a deed, and it'll be from grandma to grandchild, saving and reserving unto grandma a life estate. And the purpose of this is so that grandma can continue to live on the property for the rest of her life, so that it can't be taken away from her by the family members or anybody else, and it also helps with certain taxation things that I'm going to get to later today, called homestead, which you can qualify for a homestead exemption on a life estate. But that's postponed because the people who Marilyn?
Am I the only one?
Yes.
You had it delivered.
Wow, okay.
That's right. It was up here on the podium waiting for you.
And where is the,
I saw him yesterday. He's really thankful that you bought from him.
Does he have money from it?
Okay. That is a transfer of a present interest in food. Not like nobody. In this particular case, the chicken did not reserve a life estate. So the life estate, as we've talked about before, lasts for the duration of the person's life. Now, in theory, although it almost never, well, no, I'm not saying it never happens, but you could give up a life estate, which would also be done by a deed. You could gift the life estate. Let's say grandma decided it was time to move out of the house, and she knew she wasn't going back to the house and didn't want anything for it. She's already given the remainder interest away to a grandchild. She just has to do a quitclaim deed for the life estate to the remainder person. Then the two interests merge together, and the remainder person owns the whole thing. Now, if you remember my conversations about life estates, a gift could also be made to a third party, in which case that party would own the right to use and live in the property, not for their own life, but for grandma's life. It's a life estate for the life of another. Something, not too important. So one of the requirements of a deed, or any contract at law, is consideration. Consideration typically is money, but it's not always money. but you do need some kind of legal consideration for something to go back and forth. So typically you will see on a deed or a bill of sale or something, the words for $10 another good and valuable consideration. Truthfully, the $10 never really passes back and forth. There is other good and valuable consideration, but it's an antiquated way, it's done that way. But in the case of a gift, you would recite on the deed that this is a gift without consideration. The reason that's important is if you just transferred the deed with no money, how would anybody know that that was really an intentional act and know that that was properly done? One of the key requirements of a gift is donative intent, the intention to make a gift. The law is permeated with intent. In a lot of yes.
Repeat that word again?
Donative.
Donative.
Like a donor, but with an A and a tiv. Sorry, that's what it is. D-O-N-A-T-I-V-E. Donative. Intent to make a donation, intent to make a gift. Donation and gift being synonyms. So that intent is important. It's important to express it to show the reason for the gift. It would also show, remember there's transfer taxes called documentary stamp taxes. So you want to show why that deed of $300,000, $400,000, $500,000 piece of property you're not paying any tax on when you transfer it. A little off to the side, there could also be federal gift tax issues involved with making a gift of a large piece of property, because you're allowed to make gifts of, I think it's about $14,000 a year per person, which is the annual exclusion, and then you have a lifetime exemption, and then an estate tax exemption, which is much greater, but technically if you exceed your annual exclusion, you have to file a gift tax return. So don't worry too much about that.
So if a property is worth $200,000,
yes,
you're only allowed to give up to $14,000.
Without filing a tax return.
Right, but who really determines that?
What? The amount of the gift?
The amount that the property's worth.
Oh, there's all kinds of ways to do that. So the most informal way for this kind of a transaction to value a gift is you could just pull up the property appraiser's website and see what it's assessed for. That's the most informal way to do it.
Which is actually going to be probably cheapest because assessed value typically is a lot lower than actual market.
A little lower. I'm not talking about a capped amount, I'm talking about a fair market amount.
Okay.
But yes, so that the easiest thing to do is you go into the property appraiser's website, you see what they say the property is worth, their market value assessment, and you use that. Another way to do it, if you want to be a little more formal, and most of the estate planners will do something a little more formal, is you would get a broker's opinion of value. You find a reliable real estate broker who knows the market, who will write a letter saying, I'm a knowledgeable real estate broker that knows the market, and I believe that the value of this property is X.
So if you're the receiver of the property at that point,
Yes.
and the party gave you the tax form that
Now, the tax form is for the government. Go ahead, Bill.
Right, but the tax form goes to the government, but you're reporting it as, you're not reporting it?
No.
All you're doing is telling the government
You don't pay, the recipient does not pay tax on a gift,
Okay,
whether dead or alive,
okay.
okay? I don't mean the recipient dead or alive, I mean whether it goes by what's called an inter vivos gift, which means during lifetime, or a gift at death, I will state a little bit later. So, it's the donor who is taxed, the person making the gift. Same thing with an estate tax, by the way. It's the estate tax is not imposed. If you inherit from an estate, the tax is not imposed upon you as the recipient, it's imposed on the estate. As a practical matter, since it's the receiving people who are getting the money from the estate, it's reducing what they're getting by the amount of the tax that has to be paid. But the tax, in today's law, doesn't come into effect on estates unless it's up to around, I think, $10 or $11 million. So it's not too much to worry about unless you're Mr. Kraft. And he's got lots to worry about. Because, and believe me, I mean, I'm not going to go into estate planning, but there's all kinds of games that they have to play. Yes?
Oh, we're going to talk about the taxes on gifts a little bit later, because I don't want to ask my question now if it's something that you're going to be covering.
Go ahead, because I'm going to talk about the taxes of real estate. This is, ask the question.
Okay, so on a gift of real estate, you can avoid or possibly avoid a tax if you did something like a tenancy in common with the right of survivorship, and then the or would the tax still occur?
So, okay, Whether there is a tax or not depends on the value of the gift. It's a good question. I'm going to get a little sophisticated for just a minute to give you a taste of what kind of what kind of planning goes on to accomplish what you're talking about. So the first thing that we do is, let's say we want to transfer the property down a generation, and the property is worth $300,000, using round numbers. So the parents would then sell the property to the children. Now, what I'm talking about in a situation where everybody's got tax things to worry about. Parents would sell the property to the children for $300,000 and take back a promissory note and mortgage. Each person is allowed, and don't hold me to the $14,000 number, but I think that's what it is. Each person is allowed a $14,000 exclusion per year. If you have a married couple, on the donor side, that's 2. If you have a married couple on the recipient side, that's 2. So technically, that's $56,000 that you could gift in a year from married parents to married children. Okay? So what would happen would be each year, for the next 4 or 5 years, whatever it takes, the parents would write a letter to the kids and say, I am forgiving $50,000 of that mortgage this year as my gift to you. And so what happens is, over a period of 4 years, roughly, the mortgage goes away. There's been no use of the lifetime tax exclusion, tax credit, and you're just using your annual exclusions, which you can certainly do. No gift tax return, no issue. Okay? That's an easy way to do it.
When you say mortgage, do you really go to a bank and get a mortgage?
No. Okay, remember I talked about seller financing?
Yeah, okay.
So in this particular case, it's like seller financing, where the kids who are getting the property, buying the property from mom and dad, are signing the note and mortgage to mom and dad, and so that's actually a purchase.
Yes.
That is not a gift taking place, and as a result, you do have to pay transfer tax, dock stamps on the deed, and dock stamps and intangible tax on the mortgage. So there's a transactional cost involved in doing this, in order to avoid the issues with the gift tax.
Go ahead, I'm sorry.
No, come on.
So they do pay for it as if it's a real mortgage. But
Correct.
It really isn't.
It is a real mortgage.
But
it's a real enforceable mortgage.
It is, but it's a way really to get around the taxes.
It's a real note, it's a real mortgage, it's recorded, you just forgive it on an annual basis.
Can't you just transfer interest and ownership?
It's more cumbersome, because you want to get, I'll tell you why that doesn't work. So his question is, can't you just give like fractional interests, give a 10% interest in the property each year, right, for 10 years, something like that? The problem is, all things being equal, and going back to Steve Halmos' chart on the board, what happens to the value of property over 10 years usually?
Increase.
It goes up. Yeah. Therefore, the value of the gift is going to increase each year. What you want to do anytime you're doing estate planning and doing these kinds of things is you're trying to freeze and get the asset out of mom and dad's estate.
Oh, yeah. Now that's what I was saying is transfer the interest in like an entity.
Same thing.
Okay.
Same thing. Doesn't matter how you do it.
So, I have a son, I have a property. I couldn't just put him on the title of the property, and then we have a right of survivorship on the title, and then I pass away.
Absolutely works.
And he doesn't have a gift tax. That's my question.
Well, okay.
Or would he have a gift tax?
No. It would depend on how wealthy you were,
okay,
as to whether there was an estate tax at that time.
Okay, got it.
Again, when we go back to the example of Mr. Kraft, he would have to pay taxes because
his estate is
like
worth
when Mr.
over.
Hazenga passed away, there was taxes to be paid. By the way, if anybody's in the market for a house, their house didn't sell, so it's going up for auction. I think it's only $27 million. It's 5 houses along the.
Do you want to get a gift?
Yeah, ask them. They've given lots of gifts here. That's why their name is on the building.
No, do you want to give?
I don't. Okay.
And I don't. Say buy it.
Well, but that would require, that's why, you see, I could do that for you. I'd be happy to do that for you. And that's why you need title insurance, because it protects against forgeries. It all comes back around. Okay. If you did a deed and you didn't document what you were doing, and just, it was a quitclaim deed. Like Chase suggested, I'm gonna give him a deed to the Huizenga's house. So, and I don't pay doc stamps, and so there's no consideration. And of course, I'm going to sign somebody's name that we think has authority. Well, the lack of consideration, without my saying on it that there's a gift, makes that deed possibly subject to challenge. If you can't show that there's some intent to make a gift, then maybe it gets set aside as there was something wrong with it. So it's important for a couple of different reasons when you're making the gift to make sure that it's expressed. The other thing that we touched on briefly that is important when you're dealing with a deed of any kind, and especially when that deed is for a gift, is delivery. So, back to my example, Grandma decides she's going to give you the Huizenga mansion for Christmas, okay? So she goes to her lawyer and has a deed written up. And she signs it, and she goes home, and she puts it in her drawer next to the bed. Because it's not Christmas yet. Do you own that house?
No.
No. There's been no delivery. The deed has been signed, the deed has been tucked away, there's no delivery, the deed doesn't do anything. Similarly, or maybe even more likely, she leaves it in escrow with her lawyer and says, I'll let you know when I want you to give it to my grandson. And if it's not delivered, if it's in escrow is kind of like purgatory, but it's with an agreement, but it hasn't been delivered, therefore, it's not a valid gift. The other side of the transfer of the deed that we talked about in another context is acceptance. Now, it's very rare that you're going to find a lack of acceptance for a gift. Therefore, with a gift, acceptance is presumed unless it is clear that it's not accepted. So there would have to be a clear rejection. How would a clear rejection take place? Well, if I deeded it to you and you took it, let's say I sent the deed for recording, which is unusual, because usually the recipient would send the deed for recording. And you said, oh no, I don't want that house, it has an environmental problem, and I want to be saddled with it, you would then immediately execute a quitclaim deed back, or even a disclaimer saying I never accepted the deed, or something to show that you were rejecting the gift. I know that sounds a little peculiar, but my example is actually not too far off, because if the property were contaminated environmentally and you accepted it, then you could be responsible for the contamination, the cleanup of the contamination by virtue of your ownership. I had a bank walk away from a property where they had a mortgage on the property, the note was in default, and they chose not to foreclose, and they just released the collateral and walked away because it was a marina and it was contaminated with petroleum. So, you do have the grantee, the donee, has no obligation to accept the gift. But once it's accepted, once the donee accepts it, the grantor cannot revoke it, if it's, assuming it's an unconditional gift. There is one exception, and I may have talked about it briefly when we were talking about deeds, and I do understand that a lot of this is a lot of material that we go over, and I apologize because I'm just kind of spewing on the topics, and I'm going through concepts and terminology, and that's why I'm trying to backtrack and go over things a little bit more detailed. Remember I mentioned the Ladybird Deed. Strange name, but the Ladybird Deed was a deed saving back to the grantor of a life estate, where it's a deed to a remainder person. Grandma gives grandchild the deed, saving to grandma the life estate. But then there's another paragraph in there. And the other paragraph gives grandma the right to take it back or to convey it to a third person and take it away from the grantee. So this would be a conditional gift, and it would be subject to revocation. You can divest the remainder interest. And the purpose of this is to give some flexibility to grandma, if you will. Let's say she wants to move to another place. You know, she's done this estate planning with the condo, or with the house, and now she wants to move to the condo, or she's tired of living in Broward and she wants to move up to Port St. Lucie, and she wants to go through this. She can do that and that's the purpose of the Ladybird Deed. If nothing happens, if there's no revocation and no alternate conveyance by the holder of the life estate, then upon her death it'll go to the remainder people. Remainder man, remainder woman, remainder person. Okay. The other way that a deed could be set aside is lack of capacity. Lack of capacity means lack of mental capacity, which means you don't have the mental ability to form an intention to make a gift. Why would this happen?
Alzheimer's.
Good, that's right on there. Dementia, that's the first thing on my list. Dementia. Could be drugs. You could be under the influence of drugs and not know what you're doing. Obviously, in setting aside a deed like that, the dementia is fairly easy. Under the influence of drugs, at the time the deed was executed and delivered, would be something that somebody would have to prove. More likely than either of those things, and kind of in a slightly different category, is undue influence. Undue influence occurs when someone who is relatively close to the property owner convinces them to do something out of the ordinary. So this occurs in situations where, and this, in South Florida, we have a lot of this. What's that? No. This is done.
You said South Florida.
Okay, you said girlfriend, but let's. It's more the girlfriend. It's more Mr. Kraft's girlfriend. You remember he was 77 years old. And in this case, he was smart because he just rented. But even though he got caught, but what really happens is what we call tongue-in-cheek a nurse for a purse. Sorry, I mean, so what happens is you have the aging person who loses their spouse. Now they're 75 years old. I think he's 77, and they're lonesome, and so they find a person who's much younger, and likes the person who's much younger because much younger is much more attractive, especially when you're 77. Someone that's 47 is more attractive than somebody who's 77 to the opposite sex, usually. So now they start a relationship. And it's nice because for the older person, not only does the older person have younger companionship, but the older person has someone that if they get sick, their companion will help take care of them. The younger person usually likes the situation because the older person in most of these examples has money, exactly. Thus the phrase, a nurse for a purse. However, the situation you see, and I just had one of these not that long ago, my client bought a house from one of these situations. So what happens is now they start this relationship. And all of a sudden you see that old person has been now taken to a new lawyer, a different lawyer than the family lawyer he's been using for the past 30 years. Because you see the deed is drafted by somebody else, or the will has been drafted by somebody else. And what's happened is that the new acquaintance, the new companion, has now taken Grandpa by the hand and said, come on, come meet this nice lawyer that I know. Because he's very good with estate planning also, and he'll help you. And the next thing you know, the companion is on the deed as joint tenants with right of survivorship. And their Grandpa's estate planning and his $8 million house on the beach is now in joint tenancy with girlfriend instead of going to the family like it was supposed to. The other thing is, and that's a short-term relationship and that kind of a thing, and a new professional doing the work is evidence of possible undue influence. Now, that can be overcome. It can be overcome because if you have an older person, I'm sure many of you know older folks who are completely with it and know what they're talking about. And they can do things to protect themselves. They have witnesses. I mean, every deed and every will, everything has witnesses. You could get the witnesses to testify. Now, if those witnesses are the two secretaries in the new lawyer's office, not so much. If one of the witnesses happens to be old guy's buddy for 30 years and knows him really well, that may be good to say, hey, I was with him, I knew what he was doing. You could take a video like this. You could actually video the signing of the document and have the person signing the deed or the will say, hi folks in the audience, here I am, I'm fine, she's not beating me over the head, she's not holding a gun to my head, I know what I'm doing, these are my kids, these are my assets, screw them, I'm giving it to her. And it's okay, but that's a way to overcome the claim. And it's actually done. Listen, you have technology in today's world, so you can do stuff like that. The other indicator that something's been done improperly is if the recipient is not the natural object of his bounty. What does that mean? Well, who do you normally give your property to when you pass away? Your kids and your grandchildren, okay? Not someone you met 3 months ago, who you've been taking out to dinner or to the theater. And so if all of a sudden you've had 6 wills over the last 15 years that go to the same family members, and all of a sudden you go to a new lawyer who creates a new document and diverts the assets somewhere else, something smells fishy. So those are ways you would set aside, and I'm going, it's a good segue because we're talking about gifts. Go ahead.
Does the judge, when that's bought, then does the judge, is the person who determines who it really goes to? Or is it typically settled before it even gets to that level?
Well, there's no typically there because that would apply to any legal dispute. Any legal dispute is going to wind up in court, and a lot of them get settled first. Sometimes, like in the case I was talking about when my client bought this property, and it literally was like a $7 million house on the ocean. They did something smart. The parties, while they were not getting along with each other, agreed to appoint a third party, what do they call him, a receiver, I guess, who was tasked with selling the property. Because rather than fight over the house, which is deteriorating and has expenses, they decided to sell the house and fight over the cash. And also there was something even in one of the agreements, or maybe it was in the settlement agreement, that said that the surviving spouse could reside for 6 months before the family could do something with the house. So it was easily, it was, I don't know what happened after the fact, because all we did was put the money into the court register, per the order. So, like I said, the undue influence concept, while I started by talking about deeds, really drifts into the next part of the discussion, and that is the transfer upon death. So, transfer on death occurs at death. It's kind of obvious. But,
I have a question.
okay, bring that back to life.
No. About this undue influence. It's me speaking with someone, that's why I have the question. So, if they got married,
Yes.
doesn't the spouse now have ownership? Not ownership, but,
We'll get there.
oh, is that what we're doing?
We're going to get there, yes. But normally, now remember, I'm not talking about people fighting over the small estate.
No.
Because although truthfully, what you see in that area of practice is the fights occur at both ends of the spectrum. Either when there's Bob Kraft money or there's very little money and lots of angry people. There's angry people at both ends, but if you're when Jeff Bezos is getting divorced in a community property estate and each one's going to wind up with only $100 billion, so they're going to split $200 billion? That's not a problem. Oh, I can't tell the truth. Okay, sorry. God, that just reminded me of a professor I had in law school who was a brilliant tax professor who used to get up there and he'd go on about things and he would pause and he'd chop rooms of his, but I can't tell that story. And he'd go back to his question. I hadn't thought about him in a while. Okay, so I said, the transfer on death. Basic rule, and this permeates some of the rules here, but the basic rule, as basic as my old first in time, first in right theme, the basic rule is that title vests at death. Title vests at death. because somebody's got to own the property. If you don't exist anymore, you can't own the property. So something's got to happen to that title. All the things that we do in the public records, whether it's in probate court or recording things, that's just to show evidence of what happened. It's already happened. So where does it go and what happens? Well, the easy way, the one that you think of the most, is a will. A will is a legal document, very formal legal document, that directs who gets the property. It says, you know, I give, devise, and bequeath to my beloved, I still do this to my partners that do this. I give, devise, and bequeath to my beloved stop code. Stop code is an old, in word processing, when before the computers, when the typewriter or whatever machine it was would stop where the blank was. But the words are, it should just be devise. Devise is all you need, but most wills will say I give, devise, and bequeath, because lawyers say things repeatedly. It comes from the Department of Redundancy Department. So a devise directs where the property is going. Who are you giving your property to at your death? And most wills will start off with statements to say, this is my will. It's my last will and testament. The next statement is usually, well, again, I'm not sure that you'll see this in so many words, but I, so-and-so, being of sound and disposing mind and memory, do hereby make and publish this my last will and testament, blah, 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 blah. And then it says, and this is kind of important, I hereby revoke all prior wills. Because you want to make sure, whenever you're doing something new, whether it's a will or you're modifying something, that you make it clear that this takes over what you did before. There's a couple of different ways, a couple of different types, but typically a whole new will is done and it supersedes everything prior. The other way besides a will is a trust. We've talked about trusts a little bit. A trust is an agreement between the settlor or grantor, the person that has the ownership, and the trustee. And in some situations, pretty common in estate planning, it's the same person. So you create a trust, and I would say David the settlor creates a trust, and David is the trustee as long as I'm alive. And here's what goes on. And as long as I'm alive, I get all the income, and I have control, and I can do what I want, and I can revoke. And when I die, this person gets this person gets this person gets that. That's trust. It's helpful because, number one, a trust does not have to go through probate. Number two, if the person who makes the trust, the settlor, the grantor, those are interchangeable, gets sick, becomes incapacitated, dementia, in a coma, at that point the successor trustee can step in while the person is still alive and administer the assets for the benefit of the beneficiary. The beneficiary is the person who's entitled to receive the benefit, the assets, the income from the trust, and usually there is an income or lifetime beneficiary and a remainder beneficiary. Same as with the life estate and remainder, but this is in a trust. So in the typical grantor trust, you reserve the income to yourself, and when you die, the money goes to someone else. You also have the right, if you need to, take the principal. Yes?
Well, I was just going to say, I heard that like Rolex Corporation, the guy who made it, I don't recall his name at the moment, but he was like from an orphanage, and when he died, he left Rolex to a trust that now all of the proceeds or profit, obviously they have to pay like the employees and such, but all the profits of like the Rolex Corporation get donated through the trust to various like orphanages.
That's actually called a charitable remainder trust. Mm-hmm. And what happens there is the reason that's in a trust is because the orphans are not very good at investing money. Yeah. So when you create that, think about it. When you create that, you're creating the trust so that the trustees, and that's probably got multiple trustees, they're the ones who are managing the money.
Business, yeah.
Also, well, not necessarily. The business is run by the people running the business.
Yeah, but
the trust becomes the owner.
The business, yeah.
So the money gets distributed, and they invest it and do what they're supposed to do for the benefit of the charity.
Gotcha.
Sir?
If I create this trust, right, by signing it over whatever the asset is into it, and I name, the trustees, what happens when they die?
trustees, you have successors. So you always, so in the Grantor Trust, the person who creates the trust is usually the initial trustee, because it's an estate planning thing, it's there for protection, and you don't want to be, you don't want to have to go and ask someone else for your money. So initially, you're the trustee. Typical thing. And for income tax purposes, it's not a separate taxable thing. It's just, your money's just off to the side under a document, and it doesn't really have an effect while you're alive, so you're the income beneficiary. When you pass away, you have appointed someone else to act as trustee to take over, or when you become incapacitated. A successor trustee is a named person who takes over as trustee when the initial trustee cannot serve. Dies, resigns, becomes incapacitated, whatever the reason is.
Thank you.
So, major difference between administering a will or administering a trust is probate. People think of probate as a horrible thing. It's really not. It's really just a relatively standard, absent a fight amongst the family, a relatively standard court proceeding. And the main purpose of the probate administration is to authenticate and approve the will and how it's being administered. So, first thing to happen, yes?
What happens if they don't have a will?
We'll get there. Next paragraph. So, the court looks at the will and authenticates it by admitting it to probate. How do they authenticate it? Well, like I said earlier, a will is a very formal instrument. It has to be executed by the testator in the presence of 2 witnesses. It can be self-proved or not self-proved. Basically, self-proved is a formal notarization where the testator and the witnesses are all together with the notary in the room, and the notary signs a certificate that the will was signed by the testator in the presence of the witnesses who were in the presence of each other, and they all sat in the room and stared at each other, and then they signed their names, and the notary signs it, all this happened. And this way, you don't have to bring the witnesses forward. When the person passes away, if it's not self-proved, everybody would have to come before the court, and they'd have to testify, I was a witness, I was there, I saw him sign it, okay, good, onward. So now the court admits the will to probate. They say it's okay, we've established that it's been signed properly. They sign an order, it's literally an order admitting will. The other thing that the court does is it issues letters of administration. The letters of administration are issued to the personal representative. And you may have heard executor in some settings, but there was an executor and an executrix, sexist of course. So they got neutered to personal representative, which is more modern and more descriptive. The personal representative is appointed by the court to handle the estate and the assets of the estate, pay claims, pay expenses, distribute the money, and do everything that the will directs them to do. Sure.
No, keep going, 35.
Some wills will give the powers, all the powers necessary to the personal representative, including the power to sell real estate. Some wills will give just general powers, in which case, for things that are not in the ordinary course of business, if you will, the personal representative has to go before the court and get a court order. So that's also part of the probate court's job, is to authorize the personal representative to do things that are not automatically listed and empowered in the will. The other situation that happens inside the probate court is dealing with claims. When a person dies, they might owe money. And you can't just come and, put your hand out. So there's a formal procedure where you actually file a document in the probate court called a claim. And the claim gets processed. There are priorities of claim. If there's not enough money to go around, there is a list of order of what claims come against others. For example, expenses of administration. This is the expenses of dealing with the estate, going to court, administering the assets, collecting the assets, personal representative's fee, the expense of maintaining the property. Those come top. That's the top of the list. And I didn't bring that statute with me to tell you what the list is, but there is a list of priority. If there's not enough money, the people who have claims at the bottom of the list don't get paid. And again, that's the small estates. Now, the personal representative has the right to object to a claim. It's exactly what it sounds like. You file a pleading that says objection to claim. And that's where it goes before the court. They don't resolve it, and the court decides, is the claim legitimate? Is this something that should be paid out of the assets of the estate? Was everything, is this something that was a correct expense of the decedent that should be paid out of the estate? Okay? Yes?
No, I have a question. So, I don't know if you've heard, but the Chanel chief, he died recently, and he left his $195 million fortune to his cat. So how does that work when no one can it's not the person? It's can someone claim that money who are part of the rest of his will to take that money from the cat?
So that kind of a question freaks me out.
No, it's actually real. It's a real story. I kid you not. This is it's on major news platforms. You can definitely look it up. I just want to know how that works.
I can't help myself.
Can you adopt a cat?
Okay, so honestly, as semi-silly as it sounds, the cat's no different than the orphans. Because, well, no, you can believe me.
I see where you're going with that.
No, for purposes of this question, you have trustees who are administering the estate. Okay, the money is there, and just the same thing where the money would be used to take care of any other asset. And by the way, an animal, as much as we love animals, or at least some of us, REE doesn't. No.
If I was this kid, I'd kill a cat.
So, there's statutes for that too.
But the cat was already making money according to the cat already has its
The cat makes millions.
Yes.
Yeah, millions of dollars. My question was just it's not, I didn't know pets had, could be.
A pet is actually an asset. It's actually personal property.
Oh, okay.
And except in this case, if the cat's spray is Chanel number 46, you have a problem. You never know. So, but in this case, a fund was established, and with that fund, they're going to hire somebody to provide a home and care and food and veterinary services to maintain the asset.
But I just don't understand how the cat can just inherit all of that.
The cat didn't inherit, really.
Well,
the cat is being provided for by the trust. That's all. It's really all it is.
But no one can take that, claim the money over the cat.
Not while the cat's alive.
Oh, okay.
It's kind of like a life estate of 9 lives.
Easy solution.
Wait a minute. The kids can do something under but they wouldn't be able to do something under a cat.
Well, but you have to prove that remember, you can do whatever you want with your money. You can leave your money to the Humane Society. Would you have a problem with that?
So this man right here.
More cats, more dogs. But that's a charity, right? In this particular case, this cat was this person's companion for the past 4 years of its life, of a human's life. Okay? Very near and dear. Those of you that are pet people know that you get a lot of... So what happens to your pet if something happens to you? Okay? I can't tell you how many times on Facebook or other places you see an animal. This animal has no home because their human died. Okay?
Usually.
Okay. Anybody?
So, what happened to the cat when the cat died? So
the cat dies?
The cat dies, the money moves to the next person that's in line, right?
No,
so you can leave the door open? But I mean, you know what, so seriously, what happens is the trust would provide that for the life of the animal, now obviously it's not taking $190 million to take care of a cat. But the reality is the cat, I want to make this clear, the cat is not inheriting the money. The money is being put into a trust, and one of the provisions of the trust is some of the money is going to be spent to take care of a cat. And even if you have a palace for the cat, even if you say that the guy's 6,000 square foot house will continue to be maintained by his staff of 12 servants for the cat, there's still a limit, and that's all that they're doing is they're using money from the trust to maintain the house for the cat and take care of the cat. That's all. If the cat's not inheriting, the cat cannot give the money to kittens. The kittens would not be a beneficiary. No, the money is not left to the cat. The money is left to take care of the cat. That's a big difference.
So when the cat dies, so does...
Done. The trust will say the money goes somewhere else. Maybe to the orphans. Who knows? Okay? So it's just, and you could set up a separate trust. Honestly, this is not as wacko as it sounds. People do this all the time.
I've never.
They leave, because you're not.
Why would you give that to people?
I believe it's a comment. I'm just saying.
So here's why it sounds so funny.
Yeah.
It sounds so funny to everybody here and generally because you think the money is being left to the pet. But that's not what's really going on legally. The money is being left to a trust with a direction in the trust that one of the duties of the trustee is to take care of the pet. Makes more sense, right?
That does make sense.
Okay.
Thank you for explaining my question.
Yes, absolutely. And in fact, that's why you can't really, I don't want to say this too definitively, but it's my understanding that you cannot have a malpractice action against a veterinarian because the damages are limited to the loss of the child, which makes no sense to me at all. Okay, question, what happens if there's no will? So if there's no will, now we're gonna move on from the cats back to the humans. If there's no will, then we're still gonna wind up in the court. More likely, we have to be in the court now because there's no direction. But now the question is, who gets the property? Well, that's called intestate succession. Testate, testator, testament, all words that are all tied together. A last will and testament is a will executed by a testator or testatrix. Sorry, that's back to the old way of saying it. So that is, if you have a testament, then you die testate. Sorry.
That's what the will.
If you die without a will, it's testate. If you die without a will, it's intestate.
No,
Right.
without a will is intestate.
Intestate.
Without a will. With a will is
Intestate.
I don't know.
Okay?
One more time.
Get back to the root word, which is testament. The key. Remember, I'm trying to stay on. I'm more concerned about concepts than detailed terminology. No, I want you to hear it. It starts with the document, the testament, the last will and testament. That is the document that directs what is going to happen to your assets. It's a written piece of paper. It is a testament. If you write a testament, then you are a testator. Just like the person that writes the deed is the grantor, the person that writes the mortgage is the mortgagor. So the person that gives the lease is the lessor. I didn't get into the ors and es because that's just ridiculous. And I try not to use those words because instead of the or and e words, there are better words that are clearer in drafting. For example, instead of lessor and lessee, you use landlord and tenant. It's much easier to read. If you go back to lawyers that are 2 generations before me, I had one guy who referred to in a contract the old way of doing the party of the first part and the party of the second part. Anybody ever hear those things? Well, that's okay until there's 5 parties to the document.
Yeah.
And then the party of the first part agrees with the party of the third part, the party of the fourth part will be required to submit to the party of the second part, and you go nuts.
Who's on first?
You just can't follow it.
What's on second?
So what you do when you're drafting is you give people names. You either use their real names, or you call them landlord and tenant, or landlord and tenant and subtenant. You give them names that you can identify. And the simpler the names, the easier the names are, the tie to a definition that people can read, the better our document reads. I'm all about the document being clear. So, intestate succession, there's no will, there's no testament. So what happens? So you go to the statutes. The statutes dictate what happens. And the first thing that, and I think this question may have come up, in dealing with the girlfriend, the companion, and you said, what happens if they get married, right? Now, once they're married, that becomes a spouse. spouse has special rules. The intestate share of the surviving spouse is, I'm reading, if there's no surviving descendant of the decedent, sorry, so if there's no surviving descendant is kid, grandkid, down the line. It could be one or the other. The decedent, of course, is the person who is dead. Like General Francisco Franco, if you remember him. He's still dead. If there is no surviving descendant, the spouse gets all. Everything. The entire intestate estate. Now it gets more technical.
That's statutory?
I'm reading the statute. I'm reading the statute to you.
And so that's Florida. For statute.
Statute, yes. See, Florida statutes. Right here. So, it says on the top, bigger letters. If the decedent, now it gets a little tricky because again, we get into these situations and I'm sure it's common all over the place, but it's more common in Florida where people come to retire and replace their families than other places.
Replace the family?
Well, yeah. Yes. Because what happens is, listen, I'm the product of one of those, so, you know, my father moved here. My father moved here from New York before I was born because he couldn't get a divorce from his first wife in New York because the laws were different. Came down here, established residency, got divorced, married his girlfriend who was my mother, became my mother, and here I am. So, but that, you know, that happens. And he did it before it was cool. I mean, he did it back in the early 50s. So. Now, if you think about it, there are lots of situations. Remember that the institution of marriage was invented when people lived to be 25 years old. So, things change. People change. They don't want to live with each other. And what happens if they're young enough, or in some cases, if one of them is young enough, there will be more children born of the second marriage, and that's what happened. I happen to have had an older half brother who was 30 years older than I was. So, back to my statute, and this is where, like I said, it's a little bit complicated. If the dead person, and I'm going to try and leave some of the, see, don't read it. If the decedent is survived by one or more descendants, kids or grandchildren, all of whom are also descendants of the surviving spouse, read that first marriage. Okay? They're the children of both of them. Got that?
Yeah.
They're survived by descendants who are the children of both of them. And the surviving spouse has no other descendant, which means that she has I'm not apologizing for the sexism, it's just easier to talk this way. And so the surviving wife doesn't have any other kids. She wasn't married before, doesn't have another family. Then the spouse gets everything. Yes, I'm going to go backwards now. Now you have a married couple.
Yes.
They have children together. Neither of them has other children with other people.
Okay.
Okay?
Okay.
Wife gets everything.
Okay. Okay. I got that.
And the thought process being in that circumstance is she gets it, she takes care of herself, and when she dies, she leaves it to the kids. That's the thought process behind it. Now, we get a little off center here. If there are one or more surviving descendants of the decedent who are not lineal descendants of the surviving spouse, okay, then the surviving spouse gets half the estate. And the other half goes to the lineal descendants.
So if the guy had a child out of wedlock prior to marriage, and he dies, his spouse splits the property with the surviving, with the older child or whatever.
With all the children. Yeah, she gets half, the children get the other half. Because remember now, you're talking about, and I didn't bring that particular statute with me, it's funny you said that. But I did look at it, because I did look at the statute, but I just didn't bring the whole book, so to speak. The fact that it's out of wedlock, you mean from another woman?
Yes.
Effectively? Okay. So it doesn't matter wedlock, not wedlock. So in that situation, all the children share, because they're his children.
Okay. Yeah.
They all share. She gets half, all of his children get the other half. Yes?
So let's say he has 2 children from a prior marriage,
right.
And him and his new spouse has 2 children. Do all the children themselves share the 50?
Because all 4 of them are his, right?
Correct.
He died.
Correct.
She gets half, the 4 kids split the other half.
Even though it's her descendant as well.
In this, yes.
Okay.
The only time that changes is if all the kids are both of theirs. Okay? The idea is you're taking care of the spouse for the half, so she's got money to live on basically, and the other half goes down to the next generation, so because she's not going to give money to his former children.
She can give money to her
But she may
children.
give it to hers, yeah.
Well, hers are theirs. In this case, hers are theirs. So her half that she gets are going to wind up in the hands of her children, which are his children as well.
Yeah.
You following that?
No, I know, but I think what he was getting at is the idea of like,
if her children with the deceased, do their children together get part of her 50% as well as their...
After she dies.
And that's what they get. They don't get nothing, none of the other 50%.
No, that's correct. No, wait. I'm sorry. Should I make a chart?
Yeah.
Yeah.
I think you can see up down there, right?
Two current ones get to gift out.
Okay.
All right. Bobby and Tina, whatever.
You give them names too?
Bob Kraft.
How's that? Looks like a dog, right?
What
No,
kind of dog
that's
is
a
that?
cat with $119 million.
That's a special cat.
Okay, so let's say the deceased has...
What is that? I'm confused.
Huh?
What?
We're all confused.
That's the cat that inherited the money. Pay attention. I told you, right?
All right,
So wait, so here we have mom and dad, okay? Or dad and dad, or mom and mom, doesn't matter.
Child.
These 2 children are their 2 children, okay? These 2 children are dad's 2 children from a prior marriage, okay? We're all good. Now, by the way, remember, all what I'm telling you in the intestate can be overridden by will.
Correct.
And very often, it's the people with these family situations that spend the extra care to make sure the will does it right, because that's where you have all the troubles. This is where you have all the fights. Because, first of all, what typically will happen if it was prior marriage, not all the time, because it could be equal. These guys are usually going to be older. Okay, hang on one second. Let me try and get through this and answer your question. So now, under the intestate, with this circumstance, you get 1/2 that goes here, okay? And the other half gets split amongst these 4 equally.
So the 2 kids from the current marriage get a part of that 1/2 as well. That goes to the spouse.
This half, yes.
That's cool.
Not
Not the
this. Not this half. There's 2 halves. 1/2 is going to her, which she can do whatever she wants with.
Yeah.
It's her money. If she wants to get the new boyfriend and give it to him, she can do that. Because dad's gone, okay? The natural, it happens, it all happens. And with the new boyfriend will be younger, so it'll be the same nurse for the purse concept. Trust me, it happens. Again, I'm not making it up. But in the normal course of events, what would happen is when she dies, this is going to go here.
Correct.
Okay? At the beginning, dad's money it's divided half here, and the other half divided 4 ways. Okay?
Just make sure the children currently don't get gypped out of the 50%.
1, 2, 3, 4 get 50%
And the wife.
equally. Wife gets the other 50. Yes.
So if he does have a will,
He
at
can do
what,
whatever he wants.
no, I'm saying, so at what point, like typically, you know, maybe he drafted the will 10 years ago, and so there's a lot of excess things that, say, have not been like parceled out. Does it then kind of like depend on the will? Say there items of the will get parceled out like this, or like excess items are like we're not talked about. You know what I mean?
Oh, good question.
Because like again, like it could have been 10 years ago, and now he's got a
Good
new
question.
car, a new house, or whatever.
Thank you. Let's come back over here.
Well, what about Angela's question?
Yeah, I'm going to stop getting into those questions, and then I'll come back to you.
Yeah.
Don't let me lose that one.
I won't.
So you mentioned from a prior marriage. The institution of marriage.
Is irrelevant. But somebody said, yeah, no, sorry.
That's what I was asking.
No, Angela asked a good question. I also didn't have that statute, but it specifically says, if the child born out of wedlock, it's still his child. Right, still bloodline, basically correct, bloodline. So, Yeah. Remember, well, marriage is like a hand grenade. If you take off the ring, the house is gonna go. All right, wait, let me get back to Chase's question about what's called a pre-termitted child or spouse. Pre-termitted, and I'm not holding you to this is for information, this is way out of our scope. What happens is, if you create a will, and you name your beneficiaries, A, B, C, and D, your kids, my kids are A, B, C, and D. And then your 10 years passes, and now you have E born, okay? And then you die. The statutes consider that, and if you haven't republished your will, they will assume that you meant to include all of your children, you just didn't have one when you signed the document. Technically, and again, I'm not holding you to this, but again, this is what go to the building next door. That's called a class subject to omen, which means you're naming your children, but it's possible you could have another child. So, all right.
I have a quick question.
Sure.
When someone names you as like their executor on their will, what exactly are you supposed to be doing?
Fast quiz. Fast quiz, just for you.
Yeah.
What's the current word for the position?
I guess I'm going to be carrying out the process? No.
What is the today's legal term?
Personal representative.
Thank you.
Okay, I have it written down. Thanks, Angela.
Only because it's not even 10 minutes old.
Okay, but wait a minute.
That did not count as a quiz.
I have it written down that that's appointed by the court, so I guess that's not.
Named in the will, but the authority comes from a document from the court. But in a testate estate, it's someone who is named.
So you help me with like the child incident of if you have like more children, but what if you have again like more possessions? Like you now have a new house or a new car that's not represented.
You don't in a will, with the exception of what's called the personal property letter, okay, which is a separate document. You don't list individual items except for the circumstance where you have some particular heirloom.
And you really want it.
If you have a Fabergé egg, and you want your Fabergé egg to go to a particular member of your family, you will say, my Fabergé egg to my niece so-and-so.
You said that's not common?
It has to be something special to be done. But in that case, okay, so that's common for special things, the Fabergé egg. Do you know what that is?
No, I do know. Okay. I mean, I don't care about it, but it is.
You know what it is?
Yeah.
So, trust me, you could trade it for a car, so you probably would want one. Or probably a big car. So the concept of, if it's not special, you said you used a house for an example. Now you have a different house. You'll say in the will, if you want one of your children to have the house, I leave my house to my child, blah. All right? E. But it's whatever house I'm in when I die. Okay? You wouldn't say, now I will tell you, I've seen wills where a person has multiple residences. And they will say, my house at 123 Main Street, or my winter home in Florida, or my vacation home in Colorado, and they'll be specific about it.
Yeah, because I think like my grandparents, like on their will, I think it's something to like my grandma, like her jewelry goes to this, and like my grandpa, like his guns go to like certain people.
All right, so there's two ways that goes on. One is, those are special items.
Yeah.
Like there could be the candlesticks that somebody brought from Europe, okay? And they've been in the family for 8 generations.
So it's just up to them whether they choose to be that specific.
The other thing is the personal property letter, which is much more informal, and the will have a provision saying, I direct, because there's personal property, there's what's called specific bequests, which I'll get to in a second, and then there's the residuary. Personal property is, I give all my, it's just a general paragraph. My personal property, cars, jewelry to blah, 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 blah. Sometimes they'll just let it go all the way down to the residuary, which is basically the leftover. Sometimes they'll be specific, but the personal property letter is much less formal than the rest of the will document, the way it's executed, because you're going to change things. It could be, in your example, Grandpa has 10 guns. And he wants to give the Glock to this person, the Smith & Wesson to that one, the one he took off the soldier over here to this kid, and do those kinds of things.
Yeah.
So in the personal, sometimes if it's formal enough and important enough, where those aren't going to change, like they're antiques or there's something special, that you might put into the body of the will. More likely, maybe he's going to trade the one thing for another, okay? And then he wants to change the personal property letter because whatever he had then, he's now going to want to designate a different thing. So that's what happens to the personal property, a little bit different. In terms of the larger things, unless it's something specific. Now, when it comes to money, you can have paragraphs in there, and this is more likely, where you say, people leave $25,000, $50,000 to the housekeeper that's been with them for 37 years. It's done all the time.
Yeah.
To the, then you leave to the grandchildren and the great-grandchildren, 100, 100, 100 to this one, and 25, 25, 25 there. And then there's the situation, we had a gentleman, and each couple of years he would come in, he had 2 sons, and one would be the good son and one would be the bad son, and it would change depending upon who pissed him off. And he would change his will every couple of years. One of my partners did this for him. And he actually had my partner write into a document, I expressly leave nothing to my son Robert because he's married to that foul-mouthed slut.
And someone got paid to write that.
Well,
read that out loud.
what a lawyer should do. This is a true statement.
True statement.
So what the lawyer did, which is what you would typically do as a lawyer with that situation, he stopped and he looked at the client and he said, are you sure you want that to be your final expression? And the man said, just those words. And that's exactly what happened.
Wait, that's exactly what happened.
It's a real bread.
That's what the works.
And of course, the two, there was a point where the in brother said, I'm thinking maybe I'm going to split with my brother, split the money, and it didn't happen, and they don't talk anymore. It's sad, it happened. So that's why these things are so important, because of what really does go on. I mean, I can't make this up.
Yeah.
You just can't. You can't make that kind of stuff
Crazy.
up. Oh. Okay. I just want to come back to this for 1 second. Don't bother with the camera. But over here, what we didn't cover was a situation where she dies. This person dies first.
Dies first, like.
Dies first. So you've got.
Oh, you're saying instead of the dad, he has it.
He's got the extra kids.
Gotcha.
She dies first, intestate. The same thing happens. Half and half.
Half still goes to his kids, even though they're not his.
Let me just make sure I'm reading that right.
Because in that case, it seemed like half goes to dad and half goes to their, like, mom's descendants.
Yeah.
Right?
Yeah.
I have Angela's approval. I think this is
I follow what you said.
Well, actually, wait a minute.
Yep.
I'm sorry. That would not be the case. Because in that case, the spouse still gets half.
The spouse gets half, but then only the mother's descendants, not the
Correct.
dad's old.
Correct, because they're not her blood.
Yeah, okay.
Yes. Because we're just talking, this particular statute is now talking only about intestate succession and dealing with the spouse.
Gotcha.
So she
What
gets
about-
all, he gets all.
Yeah, and again, the dad could obviously like flow some of it through, but that's up to his discretion
Correct.
and decision.
Right. All right?
Yeah, we get 50.
Now, what? Go ahead. Question?
So, no.
No. Question?
It's like if she was alive. I mean, she dies, and then half goes to her kids.
Half will go to her kids, the other half will go to her husband. Yes.
No. She dies, he's alive. Well,
Right.
He dies, and then the money goes half
Okay,
to
so-
his kids, and then.
Here's the story. Depending upon who dies, if he dies, he has 4 kids.
That's.
If she dies, she only has 2 kids. Okay? In either case, what we're talking about here is strictly, so far till I turn the page, what happens to the spouse We're just talking about the spouse. So if there's extras that are not the kids of both of them, the spouse's share is a half. What happens to the other half depends on whose kids are alive. Okay? We're only talking about the spouse. What's that?
The amount of money that the two kids that belong only to the father, that doesn't change when the mother dies at all, does it?
No. Well, if the mother dies first,
No, and no, after,
no.
no, it doesn't, right?
Unless she leaves it in her will, which would be unlikely.
Yes.
What if the children from a different marriage are out of the country?
No, it doesn't matter.
Perfect.
That doesn't affect it. That does not affect the ability to inherit. Yes.
Oh.
So then, in the instance, the reason that adoption is so cumbersome is you're establishing blood rights.
Say it again.
So the reason that you have to sign so much for adoption is you're establishing blood rights of inheritance.
So when you get into the statutes, adopted is treated exactly the same as blood.
Yeah, no,
Okay?
but you sign it. That's why you have to report all that.
Okay. So, we spent a good amount of time talking about what happens in intestate succession when the wife died, with the wife's share. Turn the page, now what happens to the others? I'm going to try and run through this fairly quickly because it's... Okay, so after the spouse, so if the estate is... So now we're talking about, on my board example, the other half, or if there is no spouse, which is more likely in the situation. Okay? First to the descendants. Descendants are blood down, children and grandchildren. If there is no descendant, father and mother, or to the survivor. If there's none of the foregoing, brothers and sisters, and their kids. How am I doing with that semaphore? If there's none, okay, so now we're going to get complicated. If there's none of the foregoing, one half to the decedent's, the person that died, paternal, and the other half maternal, kin. It says kindred, but I'm shortening it. In the following order. To the grandfather and grandmother equally. If there's no grandfather and grandmother, to uncles and aunts and descendants of deceased uncles and aunts. I mean, it's a web.
Okay, so that sounds really intense. Because what I was under the assumption of from like, I don't know, my very small experience with anything, is that when people die, like the state usually tries to just like get that, not like in like a mean way, but like if there's like not like, I don't know, like identified people, it usually just becomes like the states or whatever.
You gotta get further down the list.
I was about to say, like, you make it sound like they're doing a whole FBI investigation trying to find people to give your house to. Like, if they can't find people, I feel like they're like, all right, whatever, we're taking it.
Okay, and that's fine, but now,
they're not doing Ancestry.com.
Actually, they're doing better than that, to tell you the truth. So what happens is, it's funny, you say that and it sounds peculiar.
Yeah, like, I don't know, like, that's why I asked, like, I can't believe that.
So there are search firms, there are genealogical search firms that you hire as a lawyer handling an estate. When you can't find people locally, or you don't find the evidence of such, you do hire companies. I'm going to tell you a funny story. Again, true stories from the files, as they say. We were handling an estate. My partner was appointed as conservator or something like that, and I was the associate, and so I got sent with the paralegal to go clean out the apartment in South Beach. We couldn't find anybody. We couldn't find any evidence of kids, family, nothing. So we're cleaning the place out so we could sell the apartment. In the course of cleaning the place out, we found a locket. It's an old man, and in the locket was pictures from the 1930s of two girls. And it turned out that he had two daughters. And because of this locket, we were able to do further digging, and we found them. And they wound up getting an estate, as it should be. Now, you might say, hey, if he hasn't seen them in all these years, but as between his blood, and you never know what happened. Maybe he had to leave, maybe he, whatever
That's
happened.
not your problem, yeah, exactly.
And before it goes to the state, and there's a word for that. The word is escheat. And that's what happens when there is no family at all and it does wind up in the state. The state doesn't take it. It only gets there as a last resort. And I'm going to tell you, there's an interesting, I didn't realize this, part of what's good for me about doing this is that I'm going back and I'm doing a little research to prepare for this stuff, and I'm getting to read the statutes that I don't spend my time reading all the time. So, they talk about the different things back to the grandparents, the aunts and the uncles, the descendants, and then if there's none of that from the decedent's side, and the decedent had a spouse who may, even if the spouse was dead, then you go look to see what the deceased spouse's family may have been, because then it'll go that way. Then, I didn't realize this existed. If none of the foregoing, this is before it cheats, if none of the foregoing, if any of the descendants of the decedent's great-grandparents, okay? So you're going back up your Ancestry.com thing. If any of the descendants of the decedent's great-grandparents were Holocaust victims, and it's defined by statute, blah, 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 then it goes to the decedents of the great-grandparents. So it can go up another generation and go, and then it says they have to substantiate their lineage. So, you know, the court has the authority to do that. And that's only if none of the above can be found and just before it goes to the state. There's a special provision that got added. Okay. Just one other little blurb dealing with intestate and testate, or either way, when you're leaving things, is the difference between per stirpes, S-T-I-R-P-E-S, per stirpes, or per capita. Anybody know what per capita means?
Sure, what's per stirpe mean?
Well, you know what per capita is?
Isn't it
Per unit.
like per
It's like
unit?
an average
It's like
of
a financial unit thing.
Per head.
Head.
Cow.
Count the people. So that if you leave it to my grandchildren, per capita, you count the grandchildren and divide equally. If I have 3 children, which I happen to have, I don't have any grandchildren, but three children, and one child has one child has 2, and one child has 3, so I have 6 grandchildren. Did I do that right?
Yes.
Did I do that right? Okay, thanks. If it was per capita, you divide by 6. Per stirpes, you divide by the generation above.
Yeah.
So my grandchildren's shares would be divided by the number of children I have, so that a third, and a third gets dropped down. So the family that only had one grandchild, the one grandchild gets a full third. Second child's children split a third, and the 3 of them split a third.
But like
That's per
the
stirpes.
grandchildren are not even really necessarily getting that third, because like if your son, like you have 3 kids, isn't that
That's
their money?
intestate, but I'm talking, no, you could, because in a lot of situations, I'm talking, now let's go, well, I'm going back to testate for the moment, okay? This is where I'm making a gift to the grandchildren.
Okay, so you're skipping the generation.
Because either, maybe my kids have too much money.
Yeah, like they're already settled and
Right.
they don't need it.
Right, okay, and that happens. Well, it's also a situation, unfortunately, sometimes people lose a child, but there's grandchildren that survive, so it's gotta be, so that's per stirpes versus per capita.
Can you explain the difference again? I mean, I get what per capita is.
Per capita is
That's
you count the
equal
number of kids equally.
division.
You're counting heads, literally counting heads.
And per stirpes,
You're counting one generation up, counting, okay? So if I'm leaving it to my grandchildren, it first gets divided by the number of children I have.
So if you have 3 children, you divide it to 3
Three.
ways first.
Right.
And then,
Then it flows down to the next level and gets divided by the number of grandchildren in each subfamily.
You said per capita, but that's only at the level of grandchildren.
Could be anywhere.
Anyway, so your children, grandchildren, great-grandchildren.
It's how you designate you want the division made.
I see.
So can you do like a waterfall and again, like say I have 100%. I can say like, I'm saying like, I have, okay, yeah. So I have 100% like overall of like my assets. And I can say each of these 3 kids of my direct kids get like 20% each. And there's, 60. And then the other 40 is divided evenly amongst like the next generation.
Oh, sure.
And you can kind of just like
Oh,
have it
absolutely.
trickle down.
Because when you start to get up with the Bob Kraft level,
You want all
So
your
you-
massage therapists to have it.
Right, well, you gotta relax, you have that much money, you can tense. So, not to mention you have to worry about good carding when your team is cheating. So, sorry, I should deflate that comment.
True.
STIRPES.
Wait.
Yeah. STIRPES.
That's called, what did it say? How do you
Stirpies. And it is not related to stirrup.
STIRPES.
PES. Okay. Remember, you know how I love to give you the basic rules and then give you the exceptions? Transfer on death, vests on death.
Yeah.
Well, it can be divested. Who can divest?
A life estate.
Well, no, we're past that. We're dead. Now that's the person that owns the whole thing. If all you had was a life estate, it ends. That estate ends when you die. So it's not affected by wills, probate, nothing.
Gotcha.
Okay? What happens has been determined by somebody else.
You're saying, in what scenario would someone dying divest them of?
No, the dying isn't divested.
Okay. Say your question.
Okay, here we go.
Yeah.
Decedent dies. Property vests in the heirs at death. However, the personal representative, the guy appointed by the court, has the right, if necessary, let's say there's not enough to go around, to take the property back. Let's go back to the house again. Well, not house is a bad example. It's 2 pages away. The house is a bad example. The investment property, the land that was owned by the decedent. They didn't have a house, they had just some investment land. And the heirs think they're getting it because it vests on death. But it turns out that there's a lot of expenses that have to be paid to administer the estate. You got to pay the personal representative, the lawyers, and then there's claims. So there's claims and expenses of administration. The only way that the personal representative is going to have money is to sell the land, because those claims come ahead of the rights of the beneficiaries, the order of priorities.
So you can't give them a preferred charge?
So, mixing things, but I count on you for that. So, the personal representative can divest, can take away the title to the property from the beneficiaries, divest them for the purpose of expenses and claims.
Okay, so in that scenario, I guess like two-part kind of question. The first one is, can that personal representative inflate costs in a manner that, like, is there ever kind of erroneous corruption where the guy
That's what the court is for. Because what happens is, and again, this is a real estate course, and I'm going through the descent and distribution, but we're naturally getting into some of the administration issues. But, so what would happen would be the personal representative has to provide an accounting to the beneficiaries. Because he's basically, it's usually a family member, and it's only when you have those kinds of situations that you start to get into fights, where you have the kids from the prior marriage and they're fighting with the wife and all that kind of stuff. So they have to file accountings. Sometimes it's monthly, sometimes it's quarterly, and certainly before the estate is finished, an accounting, and it's literally all the expenses and all the income that's happened during the course of the administration. Further, if the personal representative is laying out money and wants to get reimbursed, the personal representative has to file a claim. It's a top priority claim because it's a claim for expenses, but if the other beneficiaries then would have the right to object to it. So there's your checks and balances to avoid the corruption.
Okay, so then the next question is, can you avoid that? Like in the instance of like my grandparents, like if they already know what they want done, like do you always have to have someone be a person representative with all these like obscure costs, or can it be like a really smooth, quick thing where you should know quickly whether or not the expenses?
That's why you would do a trust.
Yeah.
If there was a situation, and they may well have it too, depending upon their sophistication. But so if they want to avoid the probate process and the court process and all of these things, then
So trusts avoid probate, essentially.
Correct.
It's like a circumvention.
correct.
Gotcha.
It becomes private. It's not subject to court order unless the trustee is doing wrong things. And then the beneficiary is going to go run to court. And the same kinds of things are going to happen. Okay, I talked about the wills, the self-proving. How do you change your will? Well, there's a couple of different ways to do that. What's that?
Picking up a pen, scratching.
No. No, that is not valid. That is expressly not valid. I will tell you, absolutely you cannot do that. You cannot do it. It's not valid.
No, I know.
That's called interlineation. And there's other words for it, I think, but you cannot do that. So, if all you want to do is change one paragraph, and you know, some wills are very long, something called a codicil. A codicil is a will-based word that means amendment.
Can you spell that?
What's that?
Spell it, please.
Cod like a codfish. Cod, I-C-I-L. C-O-D-I-C-I-L. Codicil.
That's an amendment to.
An amendment to a will.
But this is just for like a line.
Paragraph.
And this is filed with the same person typically, or can it be filed with like say you
It's not
move?
filed yet.
Well, I'm saying, say you move, and like a guy back home in another state in Florida was the person who wrote your will up, and now you have it. Can you go to somebody else and
Yes.
say, hey, I'd still like to make a codicil?
Yes, and what you would do is you would probably, if you moved like that, you would probably take your original documents. The lawyer back home, as they say, might have a copy of the file, but the original is usually with the testator, except when the testator says, no, lawyer, you keep it.
Yeah.
But if you're going to change states and change lawyers, you
It's
move
best
it.
to have it with you.
Now, so that's one way to do it. With your question, I would suggest the other way to do it, and that is to do a whole new will.
Oh, and just say, yeah, this revokes any prior wills.
Will.
Gotcha.
There's one other way to revoke the whole will without replacing it. Anyone want to take a guess?
Amendment?
You'll have to stop.
Oh, tear that.
You can actually revoke a will by destroying it. And in some circumstances, some lawyers will go so far as when a new will is issued, is properly executed, they will tell the testator, the person making the will, literally to rip it up in their presence. Just so it does, so that because that way you don't have the argument as to which is the valid will.
But, well, because like now it's like everyone can have a copy.
Right.
So it's like, what is ripping up one piece of paper when there are infinite
Because you
amounts
can't
of-
actually tell an original from a copy.
You can't. How? I've never even seen a will, so like I don't know.
Notary
like,
seal?
I'm sorry.
Notary seal?
Okay.
But that's what the judge is for.
Mm-hmm.
I mean, yeah, and there's fights all the time. Also, the other reason to keep at least a copy of the prior will, or for somebody to keep a copy, goes back to the undue influence situation.
Yeah.
So when the new companion takes the doddering old man to the new lawyer, and the new lawyer writes a new will and leaves the house and the first $1 million to the new girlfriend, or whatever the situation is, part of the evidence to show the undue influence will be the prior will, and the longer ago it was, the better, to show that that every other will he did for the last 15 years left everything to his family. All of a sudden, and it was all done by the lawyer up north, if you will. Now, the girlfriend has taken him, or the new wife has taken him to a new lawyer, her lawyer, that he has no relationship with, and all of a sudden everything has changed. So there's a reason why you want to keep a copy of the old will, at least a copy, to show that there's consistency or not consistency.
Yeah, because like I just feel like again, someone could just say they ripped it up, or the person could die, and it's like, at what point can you prove that somebody did it themselves if it was not in front of like a witness?
Well, it's always in front of a witness. You can't do it yourself.
That's
It
what,
has
like,
to be
so like
witnessed.
if the guy dies and now like his like young girlfriend is saying, oh, this is mine, this kid say, where's the will? And she goes, oh, here it is, and it's ripped, and he ripped it before he died. It's like, well, did he, or did you rip it because you found it and I asked you to present it to me, and now you're trying to say, you know what I mean? Like, yeah.
No.
That's when the courts are.
Like
It's absolutely it happens. And it happens. It's not, it sounds far-fetched, it's not.
It's like an Anna Nicole Smith deal like
Yeah.
that. So I know that his family came after her because he gave her like $90 million, or however much money it was.
This is small amount.
Yeah.
Yeah.
But it's the dollar amounts, yeah, the more money, the more the fight, but the truth of the matter is, it happens all the time. Just read the court pleadings. And that's why the wills are so formal in their execution. And you actually, we have our clients, and I don't think this is required by law. I think it just has to be signed in the presence of 2 witnesses. But we have our clients sign every single page, which when the wills get complicated, it's 30 to 40 pages. And the people don't sign so clearly. True.
So codicil.
Codicil is an amendment to a will. Okay, so we talked about the rights of a spouse by statute. Oh, just in case anybody has any misconceptions or questions that hasn't come up, Florida is not a community property state. In community property states, each person owns equally in a marriage. Florida is not like that. You are allowed to have separate property. I'm not going into a zillion rules on that, but what's that? It's not a question of fair, it's a question of how it's titled and what happens.
I can have my own like property.
Yeah, suppose you inherited the piece of property from your grandparents,
Right.
and then you got married.
Right, okay.
Should your spouse have it?
No, that's not, I
Okay.
think it should be like that across.
What about if it's within the year?
Then typically the spouse will have some rights to it, and at least to the appreciation. If they acquire it during the marriage, then usually both spouses will have a right to it. If it came into the marriage and wasn't kept separate, and it appreciates, the appreciation will belong to both of them. The rules are very complicated.
Yeah, and commingling versus.
Correct, versus keeping it separate. In fact, I just had somebody from California ask about doing a deed to Florida property, and the deed is going to be titled to woman as her separate property. And it says that specifically because father moves to California, father must have lots and lots and lots of money, and daughter has a spouse, so they want to make sure that the property is protected. So as her separate property, evidence is an intention. Really, a lot of these things, it's a situation of, if you have an intention to do something out of the ordinary, all you have to do is express it. Unless it's prohibited, and most of the things are not, because you can do with your property what you want to do with your property. So, if you want to do something weird, put it in writing. But it's all the time. I did mention earlier, adopted is treated the same as biological. Talk about procedure? Until the statute. Okay. Any other questions on death and dying and what happens?
How do you spell that? Codicil?
Codicil. C-O-D-I-C-I-L.
So what is then the best way, in your opinion, to handle?
Live forever.
Well said.
Well, no. I mean, it depends. The trust. The purpose of the trust is, if you don't want the courts involved, and you want to be able to protect for being infirm.
Okay. Yeah.
It does require you to move your assets into the trust and title your assets while you're alive in your name as trustee of the trust. Okay? All right, so before I go on to the next, what about here? Just take a quick look. Yeah, let's do a break now. Let's move to 30. And that way, we're going to go into something called homestead. And then hopefully... What's that? No.
Bunch of road
It's
it's the tropical version of the woods.
That's what we have to do.